部分我的这个or royal security general finance.
And they just need four, but then good job. You know, they didn't actually. It's open to cashback and service. SPV Secure Solutions is one of South Africa's top cash investment companies. They transport money in armored vehicles with ATMs and cash for banks, stores, and other businesses. For years, the cash in transit industry in South Africa has faced serious difficulty. Armed gangs have attacked trucks, used explosives to break into malls, and caused shootouts of civilians. Large amounts of cash across the country has become risky and sometimes deadly. Or daylight, a 29-year-old SPV think about it. No guns, no violence, no dramatic explosions, just her, a pair of scissors, a trolley, and ordinary refuse bags. Our today's story is about Batobila Mlanjeni. She was known in her community as a quiet, respectful young woman. Raised in Soweto, Idlamini, and the daughter of a pastor, she was deeply religious, often attending church and helping care for elders in the neighborhood. She kept to herself, lived a simple life, and was never known to cause trouble. After moving to a flat in Johannesburg for work, she visited home on her off day and remained involved in church. Batobila worked as a security guard at SPV, earning an honest living until the day everything changed. On July
Good morning, DM. Good morning, honorable members and all the colleagues.
Good morning, BJ. Good morning, everyone.
You good, Putedi?
Recording in progress.
Morning, Chairperson. Morning, Chair.
Morning.
Yes, Chair, we do have about 8 members in the meeting, including yourself. And then the department is here led by the minister. And then also we do have parliamentary legal service in the meeting. So, and it's 9 o'clock now. We can start with the meeting, Chair.
Okay, thanks. Good morning, honorable members. Good morning, Minister, Deputy Minister, DG, and all the officials of the Department of Home Affairs, and our colleagues in Parliament, the Parliamentary Legal Services, and the Chief State Law Advisor. We are going to focus on the key issues that have been requested by members of the committee to be updated by the department, and members will interact with these issues. We know that thank you. We know that these are the key issues that we've raised with the department of various spaces on Parliament, or members interacting with the issues that reside with the legal unit. I hope that we'll have a full detail in terms of the issues that are arising. We'll fully observe the current dynamics around the other issues in relation to Omotoso and the response of the department, including the NPA, and other issues that are involved in the department that are on the public domain in relation to the imaging company that is involved with the Wi-Fi or related matters. And I'll request that the department need to brief us fully on this subject matter in our next meeting, just for purpose of clarity and the details, so that they were all firm on the issues. I'll also request that we also deal with the other issues that are pending in relation to the which we have referred them to the Parliamentary Legal Services in relation to the Phil Craig matter. It has been raised consistently, and I think we've received the report from the department in the last meeting. We've then requested the Parliamentary Legal Service to engage on how far we can respond to the issues that have been raised by the department. It appeared to be a matter that the committee is firm to pursue, and it's important that we put it on record before the Minister and the Deputy Minister and the Director General that will be responding, and mechanism to check the status of that person. We're also noting the brief we've received last week in relation to the outcome of the court on the citizenship, and that squarely reside also as we pursue the matter of the white paper on the citizenship, migration, and protection of refugees. We are resolved as a committee that Minister DM, you ought to work very hard so that that paper is brought before Parliament. We know that they still have the process to interact or to introduce the bill or to facilitate the bill for the approval of Cabinet. You recall that they have made that clearer in terms of the time frame that we think as a committee collectively that we need to interact with the white paper. In contrary to what you've proposed in 2030, given the challenges that we're facing in the country, I think you might need to take it forward around that. I'll invite Mr. Matonzi to run apologies, and then we'll deal with the items as presented here. I'll request that Mr. Matonzi, let me request to members that we deal with the issues of the Department of Home Affairs, and then we then skip, otherwise we'll then, this which are related to legal units, the presentation, and then the deliberation on immigration amendment bill, or the responses around that, because I think we're clearer in terms of how we must move forward. It becomes the last item, so that we exhaust the other key issues that you have requested the department to brief us, because this item also is only for members of the committee to interact with. Can I get a directive around the proposed that we change the agenda? We first allow the department to deal with all the questions. I'm aware that the department is also going to NCOP, so that we exhaust the issues that relate to the department, the committee issues. Can I get an understanding, Honorable Ross?
Hey, I just want to point out that even on the immigration matters, the Home Affairs might have to give some feedback. So because it's there's presentations to do with social development and Home Affairs. So I just wanted to point that out, that they might need to be here for that discussion.
Yeah, what I'm proposing is that let's deal with the other items, and then we'll deal with that one also in relation to the report that will come. Yeah.
Okay, that's fine, Chair.
Is that an understanding, DG? Are you, so that I don't... Can you live with that, DG?
Good morning, Chair. Good morning, Minister and Deputy Minister. I think we're fine with the proposal from Honorable Ross. Thank you.
Okay. Thanks very much, Mr. Matonsi. You'll then introduce, if there's any apology, I'll invite Minister to introduce all the reports. Then the DG will highlight how they're going to present it. Thank you.
Yes, Chairperson, I do have 3 apologies. One is from Ms. Mutambit, the one that I reported previously, which is dealing with the Magistrate Commission. And then the other apology is from DDG Mavuso, who's outside of the country. Then the other apology is from Sarah Govender from the State Law Advisor. She indicated that their uncle passed away, but she'll follow the meeting on YouTube. So yeah, those are the only 3 apologies, Chair. Thanks.
Thank you. Any other apologies? Okay, thank you very much. All the apologies have been noted and accepted by the meeting. Minister, can I invite you to introduce all the presentation? Thank you.
Thank you very much, Honourable Chair Chabane, and good morning to the honourable members of the committee. It's good to be with you this morning. And indeed, we have a number of important issues that I think broadly relate to legal matters that we will cover with you today. So I think in terms of setting the scene, a couple of points just on the approach generally, and I think it's important to highlight that there has been really significant progress in this space. And I think that can be chalked up to a number of factors, but I'd like to start with the committee this morning just to indicate that as a matter of principle, the approach that the department and this team has taken to legal matters. And firstly, that we have to anchor our decisions in what the Constitution says and what the rule of law requires. So what does the Constitution say in a particular case, and what does the applicable law require from us in an applicable case? And I think that is really the first starting point. And it is an important starting point, Chair, because we have a very, very high mountain to climb in terms of re-establishing the rule of law in this space of home affairs, whether it's civics, immigration, or the asylum management system. And we cannot do that unless we ourselves are leading by example. And that has been really important for us as we deal with matters, to make sure that our decisions are always anchored in legal advice, in what the Constitution and the law demands of us, and really no other factor than that, because that builds the credibility of the department. It makes it easier and more effective when we are arguing in court. And I think broadly in the public, we have to do, as I mentioned at the launch of the Anti-Corruption Forum, we have to do a lot of work to remove the perception, remove the stain of state capture and corruption, not only from Home Affairs, but also at Home Affairs. And I think that is part of a process of building credibility and legitimacy in society, to make it clear that whether people have their own views, our decisions are based and guided by the law. And that obviously has a very big impact on how we deal with legal matters, the type of which we will discuss with the committee today, because that then also enables us to make decisions that will reduce the load of legal cases on this department. Now, Chair, I think if we go to the starting point, we have to say that this is one of the most litigated departments in government. I'm not sure exactly how it compares to others, but there's no doubt that this department has traditionally dealt with a huge amount of court cases. And those things have really detrimental impacts on the ability of the department to function. Firstly, there's the financial side to it. The contingent liabilities that come from legal exposure, as well as just the day-to-day cost of spending so much money on legal cases. And I think that is in and of itself, in the current budget environment, a very clear reason for us to focus on this area and make sure that we reduce the burden of legal cases on this department. I would say it is part of the spending reviews and the efficiency gains that has been much talked about. And I think when the presentation follows, we will see progress in that regard. I don't think we have figures yet on the financial side, but I think this is a work in progress, and hopefully during this financial year, we'll be able to quantify the savings that have come from this work. But it really is, I suspect, hundreds of millions of rands that we can save by reducing the burden of these cases on the department. And I think just to give the committee a flavor of that, the one issue we've dealt with for a very long time is class action cases. I think all members of the committee will be familiar with this. And it really relates to, in this category, routine cases where routine issues are brought to court. So someone applies for a document. Most of it will relate in the visa space, but it could also be ID documents or passports. And then they end up going to court to compel the department essentially to do its work. And those really are the low-hanging fruits. Those are the kinds of cases that we should eliminate. Those are the kind of cases that unnecessarily burden the department. And there really were thousands of them. I think if we come to the presentation, the reference is to 1,684 class action cases alone. So this is just one category of litigation against the department, and they broadly would have involved these kind of issues, procedural issues, people saying, I've applied, but I've waited 1, 2, 3 years, and now I'm taking the department as part of a class action to court. The good news, Chair, is that we've seen a 98% reduction in the number of class action cases. I think that is something to be celebrated. I think it's an extraordinary achievement and a testament to what we can achieve if we work in a focused way on solving problems. I think it's important to point out that a lot of this has to do with the work of the backlog project. And I want to again thank DG Makode, as well as the entire immigration team, the backlog bomb squad, everyone who's worked on this, because this is the fruit now, I think, one of the fruits of that project. So we can imagine if we have 98% reduction in those class action cases, just how comprehensive the savings would be from them. There are obviously also other cases that are not necessarily taken on a class action basis. They are taken on an individual basis. And there too, we have seen a very significant reduction in the number of new cases. So obviously, there's a bit of a hangover, Chair, where there are cases that are in progress and that need to be dealt with that would have predated even the work on the backlog. But when you look at the new cases that are coming in, that's where we can observe the reduction in that space. Again, technology has been an important part of our recipe here. We have a digital case management system now in place, and we are migrating those paper files onto the digital system. I think it's fair to say we still have more work to do to fully exploit the data analytics capacity of the case management system. And I think that there's ongoing work that is required in that space so that we can monitor and pick up trends and cases more early in the process and make sure that we are able to deal with them. Chair, I think the final point to make on this is then obviously that we also have, cases where the department needs to make a decision. And I think this goes back to my initial point around anchoring ourselves in the Constitution and the rule of law. So we do not regard litigation as something that we must always oppose and fight no matter the cost, because the cost for taxpayers is enormous, absolutely enormous, in front of courts. And it's only legal firms that benefit from that kind of approach. So as I said, we are looking at cases, and I think in a much more merit-based way, looking at whether there are prospects of success, and certainly not making decisions to just oppose things for the sake of it, or to, I think even more dangerously, go to court on matters that we have advice or indications or a clear understanding that we have no prospect of success, because that is actually wasteful spending. That is actually a willful act that costs South African taxpayers. But I think also we have to be clear that if you go to court, and especially when things reach the Constitutional Court, as some of the matters that are coming up on the agenda, that it is very, very dangerous for us to willfully take cases that we can lose, or to respond to court cases and say, basically, we don't respect what the Constitutional Court has said, or we don't respect broadly what the courts have said. That is not the business we are in. We respect the Constitution. We respect the responsibility that we have, all of us really as members of Parliament, to safeguard the Constitution. And so even where we lose cases, which we believe had good prospects, you will have seen that we absolutely fundamentally uphold the sanctity of our Constitution, and we protect that. We have a responsibility to protect that. And when politicians go to court as a way of kind of scapegoating on issues and scapegoating the courts because they don't agree with an outcome, or even worse, because they knew they would lose, but they tried to make a political point, that is very dangerous for our constitutional democracy, because it undermines people's trusts in the court, the judiciary, and our Constitution itself. So, Chair, I hope that is helpful in terms of the broad approach that we have taken. Obviously, we will go through some of the individual rulings that have come down, judgments that have come down, as well as indications of progress in complying with those. But I do think the fundamental point to make here is that we are now winning the battle against this monster that we found lying on the desk. These enormous piles of court cases, these really devastatingly expensive matters, and some cases have been reduced by really meaningful amounts. So we have more work to do. We have to optimize our use of the case management system, and we have to continue to make sure that we safeguard taxpayer money and don't see courts and court cases as something that we can just basically not take seriously. Those are really important principles, and we are happy to then take you through the specifics of that. Thank you very much, Chair and honourable members.
Thank you very much, Minister, for your remarks. Can I invite the DG?
Good morning, Chair. Good morning, Honourable Minister and members of the Portfolio Committee, and also the team from the Parliamentary Legal Services. So, Chair, on the agenda, the first matter that you requested us to speak to, which Mr. Yusuf Simons, the Acting DDG Immigration Services, will take you through, speaks to the state-funded legal representation of undocumented foreign nationals in South African courts. I'm not sure, Adam, if you will start sharing the presentation from your side. The second part that you will deal with, it's the collaboration that we have, Chair, with the Department of Social Development, in particular, in how to address particularly those that are within the vulnerable groups, whether it's children, whether it's pregnant women or members of the LGBTIA+ community. So, Mr. Simons, if you can start with that one. And then the second presentation, Chair, you asked us to present on issues emanating, as the Minister correctly indicated, from the Concord, those judgments and the implications for the Department of Home Affairs. And I think the last one will be the summary that the Minister has provided on the contingent issues related to the litigation and how we are managing the contingent liability as well. So through you, Chair, if I can invite Mr. Simons to take you through the first presentation, and that will then be followed by Advocate Malagate on the others. Thank you, Chair.
Thank you, TG. Mr. Simons.
Thank you very much, Honorable Chair, and good morning, Honorable Chair. Good morning, Honorable members. So good morning to our Minister, morning DM, morning DG, and everyone on the platform. So DJ has given a very good introduction. If we can go to the next slide, on the purpose of this presentation. And Honorable Chair, it was a matter raised by one of the members about 3 weeks ago about what's the processes in dealing with undocumented foreign nationals, particularly migrant children and minors in that regard. So this is the purpose of the presentation, as DG alluded to, is to talk about state-funded legal representation, as well as the collaboration between the Department of Home Affairs and the Department of Social Development when it comes to undocumented foreign and migrant children. Chair. The next slide, Chair, speaks to the first item, which is the state-funded legal aid for foreign nationals. Now, the Department of Home Affairs is mandated in terms of our legal provisions to arrest any undocumented foreigner and those who transgress the immigration legislation and the legal frameworks. So these charges are provided, Honorable Chair and members, in terms of the Immigration Act of 2000, as amended, particularly in terms of Section 34 and 49. It's not mainly confined to those sections, but there are other related sections in the Immigration Act as well, Honorable Chair. And in terms of Section 35 of the Constitution, all who appears in a court of law is allowed and is entitled to legal representation, Chair. So in terms of the procedure for legal representation, Chair, if an illegal foreign national wishes to do so, wishes to request a legal representation, the Legal Aid Board, Chair, through the Department of Justice and Constitutional Development, facilitate this entire process. So DHA, Home Affairs, is not involved in any way in arranging or facilitating their legal representation, Chair. So on this point, clearly it's not a function of the Department of Home Affairs for state-funded legal aid for foreign nationals. That resorts solely and squarely with the Department of Justice and Constitutional Development. Then if I can go to the next matter, Chair, the second part of the presentation is then how do we collaborate between the Department of Home Affairs and the Department of Social Development on vulnerable groups. Now, a common observation that we have observed, Chair, in the managing of our migration is that there has been a slow increase in undocumented children that we encounter. Undocumented children is defined as either without their moms or unaccompanied. So the vulnerable groups, these children, are mostly found on streets or informal areas as undocumented foreign or migrant children, and it's part of a complexity, Chair, and I guess this is why the Portfolio Committee also raised it. It's a complexity in how to deal with the undocumented minors that we encounter. The responsibility and perhaps the mandate in managing this reality, this complexity, Chair, as rightly pointed out by Portfolio Committee, resides with both the Department of Home Affairs as well as the Department of Social Development. So in terms of legislation, Chair and members, the Department of Home Affairs enforces the immigration provisions and administer determination of status, while the Department of Social Development administers the provisions of the Children's Act of 2005. So the Immigration Enforcement Unit, through our normal conducting of operations, enforcement operations, would encounter those vulnerable groups, Chair, when we do have these operations. So it's quite important that when we do arrest or encounter these vulnerable groups, and the later slides will also define them a bit further, Chairperson, it's absolutely important that there's a strong collaboration between the two departments of DSD and DHA. In terms of the DHA Home Affairs involvement, Chair, we are a key stakeholder and participant in the structures of the Department of Social Development, be it on immigration matters, be it on civic matters, be it on late registration of birth, on birth registration, Chair. We're a stakeholder and a strong participant. And we actually, as a Department of Home Affairs, we participate in all the platforms of DSD when it relates to undocumented and migrant children and vulnerable groups. So in normal course of events, Chair, any illegal foreigner who is arrested for transgressions relating to Immigration Act is to be deported in terms of legislation, following, and importantly, Chair, following court processes. In the case, however, of undocumented and migrant children, the agreement between the Department of Home Affairs and the Department of Social Development is that those children are handed over to the Department of Social Development for safety in places identified by the Department of Social Development and are not kept at Landela Holding Facility. The deportation of these children that's undocumented is facilitated between three entities, which is the Department of Social Development, Home Affairs, as well as the BMA. The BMA's involvement is to ensure a smooth facilitation process across the borders. This is the involvement of Home Affairs with our partners, Chair. Then in terms of vulnerable groups, which the DG has mentioned, there are 4 areas of vulnerability. The first one is language, those who requires interpreters. So foreign nationals, Chair, and members who are illegal and apprehended are communicated with in the normal course of event in English. In an event that they are unable to speak English, but they are part of a group, the first action would be to identify one of the group members that might be able to act as an interpreter for the persons that we have apprehended. If no one can speak or understand English, Chair, an interpreter will be acquired to assist in informing the particular individual about the arrest and the related rights in terms of legislation. Now, the person in this course of event, Chair and honorable members, the person will be detained and the department will acquire an interpreter either through the courts, through the embassies, or even allowing the person the opportunity to contact a person who can act as an interpreter in this regard, so that we can administer the rights to that particular individual. The second group of vulnerabilities, the one that we are engaging with here today, Chairperson and members, is children and vulnerable groups. So the department has developed a standard operating procedure. It's in draft form, Chair, at the moment, and it's in the process of development that cedes some of the functions to the Border Management Authority. In terms of the next 2 vulnerable groups, which is pregnant women, as well as foreigners who are members of the LGBTIA+ community. When it gets to pregnant women, they are handed over to DSD to facilitate and assist Honorable Chair and members. When it gets to the members of the LGBTIA+, they are managed within the correctional services provisions when they are in the care of the Department of Home Affairs at any of the centers where we do encounter them, Chair. So that is handled through those provisions. Then the final slide, Chair, speaks about the closer collaboration and in collaboration with Department of Home Affairs and DSD, which I've touched on earlier as well. But just in conclusion in this development and involvement, Honorable Chair and members, in terms of Section 110 of the Children's Act, immigration officials are listed as one of the actors that must report cases of child abuse. This includes unaccompanied and separated migrant children. Upon such condition, they must report to the Department of Social Development or to SAPS in the area where the child was identified. That is the close cooperation between the Department of Home Affairs, again, with DSD and SAPS that's emphasized here. So, Honorable Chair and members, the principle of non-discrimination prohibits any discrimination on the basis of the status of a child as being unaccompanied or separated, or as being a refugee, asylum seeker, or migrant. And as such, Chair and honorable members, the Department of Home Affairs must provide identification documents to children who qualify according to the departmental legislation, as well as social workers should assist children to apply for any formal recognized identification documents which the child might be eligible for, and they will collaborate with stakeholders, Honorable Chair and members, such as the embassies, high commissions, or consulate, where the child originates from, and any other authority that might assist. So, Honorable Chair and members, as far as us, as part of the recommendation, we then recommend that Portfolio Committee note the briefing on the state-funded legal representation of undocumented foreign nationals, as well as the collaboration and close collaboration and important collaboration between the Department of Home Affairs and the Department of Social Development when it comes to the undocumented foreign and migrant children. I conclude. Thank you very much, Honorable Chair and members.
Thanks very much, Mr. Simons. Advocate Malekate.
Good morning, Chair, members of the Portfolio Committee, Minister and Deputy Minister, as well as the Director General and the Deputy Director Generals on the platform. Chair, mine is to present on the Constitutional Court judgments where we have been requested to develop legislation in order to cure the defects that have been found to be in contravention of the Constitution. There are three key judgments that we would need to speak to, and those are also impacted by the judgment that came out on the 15th of May 2025 on the Scalabrini Center of Cape Town versus the Minister of Home Affairs, where the Scalabrini had challenged Section 4, 1, F, H, and I. So, Chair, if we can go to the next slide. The purpose is just to provide a briefing to the Portfolio Committee, as well as to provide a progress update on the matters on amending legislation related to, one, the Immigration Act. This follows the Constitutional Court confirmation judgment in Raymond versus Minister of Home Affairs. Secondly, we would then provide an update on what we have done so far since the Scalabrini Center for Cape Town judgment, and also end up by talking to the One Movement South Africa Constitutional Court judgments in relation to the Electoral Act. So, Chair, when it comes to the Raymond judgment, Chair, we want to submit to the Portfolio Committee to be reminded that this judgment, in this judgment, the applicants were challenging the provisions of the Immigration Act in as far as it relates to sections 10.6, 11.6, 8, and 18.2 of the Immigration Act, read together with Regulation 99A of the immigration regulations. And in this case, the Constitutional confirmed the High Court judgment that these provisions offend the Constitution and are therefore invalid to the extent that they require a foreigner who may have been a holder of a Section 11.6 visa, which is a visitor's visa, wherein the holder would have indicated that he wishes to enter the Republic of South Africa and reside in the Republic of South Africa based on the relationship that he or she has with a South African citizen or a permanent resident permit holder. And the holder thereof would also have been a parent of a child who the child is also a South African citizen or is either a permanent resident. And he is currently or she is currently fulfilling his or her responsibilities towards the child, or if he could demonstrate an intention that in the near future he or she would be fulfilling the responsibilities over the child. The law had then required that these individuals would cease to work and would need to depart from the Republic because the good spousal relationship that the visa would have been issued on the basis would have lapsed at the end of the relationship, and it would require that such a foreigner would need to depart from the Republic and apply for any other new visa whilst outside of the Republic. And also, when we look at Section 18(1) in the next slide of the Immigration Act, it also did not allow for a parent who is a holder of a relative's visa, and there was no condition granted for this individual to conduct work while he is in the Republic of South Africa, and this had been found to offend the Constitution as far as it requires that. So it has an impact on the parents' rights to fulfill the responsibilities of a child. So the Constitutional Court had then found that these provisions are not in line with the Constitution and therefore invalid. And in this case, they then proposed a reading mechanism wherein they have indicated that between the date of the order of the Constitution and the time when Parliament would have promulgated an amendment bill to give effect to the Constitutional Court judgment, the provisions would be read in the manner that we have just explained above. And Parliament, together with the department, were given 24 months to cure the defect, and the Minister of Home Affairs was also given the 24 months to amend the Regulation 99A, because the power to make regulation is vested in the Minister of Home Affairs. So if we were to look at that, we need to finalize and deal with the Immigration Amendment Bill in a quicker manner. So what the department has then done, we proceeded to draft the requisite immigration bill in order to give effect to the judgment. We have, following the finalization of the bill, we submitted it to the Office of the Chief State Law Advisor, as it requires in the operating standards for developing of legislation within the Republic, for a preliminary certification opinion on the constitutionality of the legislation, and for the Department of Justice to indicate whether or not the provision as we have are in line with domestic law. We have received the certification opinion on the 25th of February. We received the first certification of opinion, wherein the Office of the Chief State Law Advisor was also requiring the department to clarify certain issues, and we have clarified that. And on 24 April, we then received a final certification opinion, wherein the Office of the Chief State Law Advisor is saying the bill as it is sound and does would stand constitutional muster and does not offend the constitution. In fact, that it is in line with the judgment. We submitted this to EXCO on 5 May, and EXCO has approved it. And following EXCO approval, we have now routed the requisite submission to the minister, requesting the minister to approve the bill, so that we can then subject it to the other processes en route to cabinet. What we have also done, Chair, in terms of the operating standards in developing legislation in South Africa, is that each and every policy or amendment or legislation must be subjected to the socio-economic impact assessment system report with the Department of Planning, Monitoring and Evaluation in the presidency. This is looking basically the socio-economic impact assessment report looks at what would be the impact on the socio-economic rights of the population in South Africa, and to then see whether or not the legislation is budgeted for or there are any other budget implications, whether the department does have the budget to carry the cost that may have been identified as it relates to the policy or the legislation. We are not required to request for a full CS report because this is a constitutional mandated piece of legislation. There's a process wherein we request an exemption from DPME as it relates to the socio-economic, to the CS report. But however, all that is required in the CS report, we need to respond to. So we have requested this document. And when we are armed with these documents, both the CS report as well as the certification of opinion, then once we are also in receipt of the approval by minister on the draft legislation, we will then submit the legislation to the JCPS cluster, starting with the development committee. And once we get approval and go ahead, we will table the bill with the JCPS directors general. And once we get the approval of the director generals, the minister will then table it with the JCPS ministers for support and approval. Once that is obtained, the bill will then be tabled to cabinet for cabinet to approve the introduction of the bill into parliament. Once all of that is done, chair and members of the committee will then submit the bill to parliament following the joint rules of parliament in how the minister introduces bills into parliament. When it comes to the Scalabrini matter, this is the matter that sought to deal with Section 22, 12, and 13 of the Refugees Act. Section 22, 12, and 13 were introduced sometime in 2011, if my memory serves me well, which was the last amendment on the Refugees Act, and introduced a requirement that in the event that and this was in line with when we read Section 23 of the Immigration Act. So basically, anyone who enters the Republic of South Africa must do so through a port of entry. And when they are at a port of entry, that is when they will declare their intention to enter the Republic of South Africa for purposes of applying for refugee status within the Republic. Any other person who enters at any other place other than a port of entry, in terms of Section 22, 13, we had then required them to do certain things. But coming back again, the provision then also introduced an element of saying that if an asylum seeker who at entry point applied for asylum in the Republic and does not following its expiry, because when an asylum seeker visa is issued, it's issued with an expiry date. If the visa expires and 30 days later, the asylum seeker has not renewed his or her visa, the law had then said this would such visa would be deemed to have been abandoned, and the application would then be dealt with as an abandoned application. So the High Court in the Western Cape found that this is in contravention of the Constitution, and also offends the principle of non-refoulement, and that it does not provide for the finalization of the application that has been submitted, and requested that the department would need to finalize the application prior to considering it as abandoned. And there is no injunction on this matter, and therefore we have developed it because we needed to ensure that there is no confusion in the statute book, that we needed to indicate that these provisions have been found to be unconstitutional, invalid, and therefore must be removed. However, we found in the next slide that when we came back, the office of the chairperson of the Refugees Appeals Authority, as well as the chairperson of the Standing Committee for Refugees Affairs, as well as the then acting director for IMS, the Director General for IMS, have found that there is, in actual fact, value in treating this type of applications as abandoned, and that perhaps the department should consider drafting a legislation and increase the number of days from 1 month to 180 days, in line with the provisions of the Administrative Justice Act. This is the rationale and the reason why we came up with the amendment bill itself. But when we subjected the bill to the Office of the Chief State Law Advisor, for the Chief State Law Advisor to provide us with a preliminary certificate, they reminded us of the paragraphs in the Court Judgment, and reminded us that in actual fact, there is no reason, or there should be no reason why the department should be increasing the number of days from 1 month to 180 days, because the court has found that looking at the Constitution, the provisions are clearly arbitrary, and because asylum seekers would no longer be deported solely on the basis of their claims, but that there are external circumstances that we needed to look at, which relates to the location of the RROs and the length of the queues and the workload within the RROs. And given that, the Constitutional Court was of the opinion that when we look at the principle of refoulement, that these provisions as they are, they do not deal with the claim itself, but presupposes that the person does not want to proceed with the claim, and therefore the department must proceed to deal with the claim to its finality and pronounce itself on the merits of the claim. So if you go to the next slide, okay, this is just to remind and to submit to the Portfolio Committee what the Office of the Chief State Law Advisor had indicated. But in the main, Chair and members of the community, the certification opinion from Oxley is saying that the increase in the number of days is not in line with the Constitutional Court judgment, and that the department may consider not proceeding with the legislation as it is, and so in paragraph 15 in the next slide of their opinion, they specifically indicate that there is no because the consequences of the deemed abandonment is that the merits of a claim for asylum are never considered. It therefore indicates that the asylum application would not be considered, let alone determined, and it is therefore not clear how the refugee status determination officer or a standing committee or the appeals authority is going to finalize the application as contemplated in the proviso that is sought to be inserted. Then in its conclusion, Oxlade then says they view the amendments that we sought to make in section 22, 12, and 13, that they say these amendments do not address what led to the subsection being declared inconsistent with the Constitution. And in their view, therefore, it would not pass the constitutional muster. Chair, we, having considered the certification opinion and the Concord judgment, we are of the opinion from the department side that maybe it may be prudent for us to look at the impact of this, relook at this, discuss it again with the IMS, and see if this cannot be placed within the supplementary white paper that we're dealing with, so that we are able to have time to apply our minds on whether or not it's prudent to insert provisions that then deals with issues relating to abandoned cases where asylum seekers had never made contact with the department or attempt to renew their applications. Secondly, Chair, in the next slide, you would, on the 15th of May 2025, the High Court in the Western Cape just last week found the provisions, section 41H, 41F, 41H, and 41I of as well as the section 21B of the Refugees Act, together with the attendant regulations, that they were also inconsistent with the Constitution and invalid. And the court in this matter has, because any judgment where a court has declared a piece of legislation or a provision in a piece of legislation to be unconstitutional and invalid, such an order is required to be confirmed by the Constitutional Court. However, the department is also of the considered view that when we deal with the supplementary work on the white paper, we need to reflect on what the High Court has indicated, and try and see what would be the impact and how do we deal with this. Once we have finalized this work on the supplementary work, it will then give us a proper understanding on what provision we would need to set in the piece of legislation that would then follow the adoption and the approval of the white paper on the matter. But we do realize that the Constitutional Court is yet to confirm this judgment, but we are also alive, given the experiences, that the Constitutional Court does not veer far from what the High Court would have indicated. In fact, in most instances, the Constitutional Court has always confirmed the decisions of the court of the first instance in any matter. The last matter that we wanted to submit, Chair, and we're submitting it, it's not part of the agenda for the portfolio committee today, but we are alive to the fact that there is a Constitutional Court judgment. We are also alive of the fact that the Constitutional Court has ordered both Parliament and the Department of Home Affairs, together with the Independent Electoral Commission, to cure the defects that have been found to be inconsistent with the Constitution, And this relates to Section 31B, 3A or Roman numeral 1 and 2 of the Electoral Amendment of the Electoral Act, which was introduced into the Electoral Act via the Electoral Amendment Act, which has just recently been passed in 2023. You would recall that this was one of that legislation that allowed for independent candidates to stand for national and provincial elections. And also there was an element related to the requirement that Parliament must make a resolution on the upper limits and the disclosure threshold. And you recall that also Parliament was seized on this matter. However, there is a constitutional injunction where Parliament and the Minister of Home Affairs were given 24 months within which to cure the defect that has been found. And what we want to indicate to the Portfolio Committee is that properly calculated, the period calculated from August 2023 would lapse in August 2025. And in given this, we prepared the bill. We submitted the bill to the IEC for their consideration and concurrence. We can report that following the interventions both from the department, from the Director General, we have spoken to both the IEC. We have also spoken to the Parliamentary Legal Services, and from those consultation, both the Parliamentary Legal Services and the IEC initially are of the view that perhaps the matters that this amendment bill seeks to deal with, these are matters that it appears that these are matters that the Electoral Reform Consultation Panel is seized with. Secondly, that these are the matters that the Portfolio Committee currently is seized with in determining and providing the report for Parliament to take a resolution on the upper limits and the disclosure threshold. So in that vein, they agreed that we are going to have to meet with both IEC and the Parliamentary Legal Services so that we can then assess whether there is a necessity for us to proceed with this bill, or whether the matters can be properly dealt with by the panel in the report that they are currently developing. So in this manner, Chair, we wanted just to indicate that there are conversations that we are having in order to ensure that the judgment is adhered to. Chair, in the final, we want to submit to the Portfolio Committee to take note of the progress that we have made in amending the 3 pieces of legislation, but also to take note of the efforts that we are taking in order to give effect to the one movement judgment and to holistically ensure that whatever that is happening, the anticipated bill does not offend or does not go against the work that is currently being undertaken in ensuring that the regulations relating to the upper limits and the disclosure threshold are then made by the President. Chair, we submit.
Thank you very much, DG, with your team, Mr. Yusuf and Advocate Malekate, on the brief update, the issues that we have requested to interact with. Can I invite members to comment if there's questions to raise around this matter? Honorable Mokhale, can I recognize any other member? Okay, Honorable Mokhale and Honorable Ross for now. Can proceed.
All right. Thank you very much, Chairperson, and greetings to honorable members, the Minister and the Deputy Minister, and Home Affairs officials. Chairperson, let me start by firstly appreciating the presentations. I'll just raise a few issues, Chairperson. First of all, I think we must appreciate the update that we are receiving on the cases that Home Affairs is currently settled with. It's very proper, and I think, Chairperson, going forward, we should be getting such kind of reports on a regular basis because some of these cases are very much important. They are of huge interest, not just for us, but for the people of South Africa. Chairperson, just maybe a clarity on the issue of unaccompanied children. They mentioned there that, you know, it's something that they are starting to pick up more and more of such cases. So I just wanted to understand as to like which are the countries which are leading in this regard in terms of you know, the number of unaccompanied children from specific countries coming into the Republic. And also, Chair, with regards to these unaccompanied children, we know there was a judgment some couple of years ago that dealt with undocumented children who are in education, that they must be allowed to pursue their education even if they don't have the necessary documentation. So I just want to understand in that regard, how does Home Affairs deal with that? Because for me, it seems like a contradiction of some sort that on one hand, we will take these unaccompanied children under the care of social development while you are processing them. But on one hand, the Constitutional Court says we must allow them to pursue and further their studies in our schools and so on. So I just wanted to understand how those issues are dealt with. And then, Chair, I think we would have appreciated to get much more in terms of the number of high-profile cases that the department is currently seized with, chief among which is the issue of the ZIM permits. We have not received any update on that, and would have appreciated to get an update as to what is happening. I know the department is appealing the Supreme Court decision. So it would have been proper for us to be updated as the department, as the committee, as to exactly what are the issues regarding that case. And also, Chair, the bungling of that case of Omotoso last week, Monday, I think we would have, we're supposed to be updated in that regard as to what exactly happened there with regards to the case of Omotoso and why the department failed to charge him within the 48 hours that they are supposed to charge him. So I think those are some of the issues that are not dealt with, but I just feel that and believe that we should have received an update on some of these cases. The Rungo case, the Mazibuko ruling of the blocked IDs and so on. We really need an update on some of those cases, Chair. Thank you very much, Chair.
Thank you very much, Honorable Ross.
Thank you, Chair, and greetings to everybody on this meeting. Chair, I think the Minister made a very important point about the need for a focused approach, and we certainly welcome the case management system that is mentioned in one of the reports. I think we had first met with Minister Motsoaledi in 2020 when there was really a crisis about the amount of litigation against the department. And it's good to see that finally now there is a case management system that has been put in place to help manage these cases, etc. Chair, I wanted to start with this, the Legal Aid Board report and the Department of Social Development. So it appears that state-funded legal representation of undocumented foreign nationals is available, and that there is a collaboration between Home Affairs and DSD on undocumented foreign and migrant children. And on slide 7, it talks about the fact that social workers assist these children. So now we're talking about undocumented foreign children. That they assist them by liaising with their High Commission or their consulate where the children may originate from, and try and help them get documented or have the issues resolved. And I think it's important, Chair, that at some stage in the future that we have an engagement with the DSD on the matters that affect this documentation of these children from foreign origin, and also to raise the question whether children of South African origin are getting similar assistance from the Department of Social Development. Because, Chair, in our schools today, there are on any given figure, there are approximately 500,000 children that are undocumented. And it's the number of, so basically the way the LURIT system works in the Department of Education is that it recognizes a South African or a child of South African origin and a child of foreign origin. And the children of South African origin that are undocumented, it's a much bigger number. But this issue of how we deal with refugees and undocumented children, it has a big impact on how we document our own South African children. And so I think we really need to explore this more. Is this kind of assistance being provided for South African children by DSD? I know it is supposed to be. There are supposed to be social workers that assist children from child-headed households to get their South African documentation. And I'm not going to belabor the point, Chair, but I think we really need to investigate that side of things to determine how exactly are these children being handled and assisted, and whether our South African children are getting the same level of assistance that they are. Chair, I also want to touch on the Raymond matter and just get clarity whether this effectively qualifies the parent of a South African child or permanent resident, whether it effectively gives them permanent residence. I'm talking about the foreign parent of a South African child or permanent residence, because we have a situation in South Africa, and I think it might be the case that Honourable Mahali was alluding to, but there was a case in recent times where it said if a child reaches the age of 18, they're undocumented, they've never travelled out of South Africa, then they're entitled to apply for citizenship via naturalisation. But given this Raymond judgment, what would happen if this had to take place? And then the parent suddenly arrived and said, no, this is my child, and I'm willing to now care for them. I'd just like to get an understanding of that, if Advocate Malakati can assist. So I think the bottom line, Chair, is that when we consider the white paper on citizenship, immigration, and refugees, we shouldn't consider them as three different silos, but they're very much interlinked. There was a former Home Affairs Minister that stated they're going to make the application process for citizenship, late registration of birth, more difficult
to stop this thing of foreigners applying for their citizenships. But the unintended consequence is that South African children really struggle to apply for their citizenship. Thank you, Chair.
Thank you very much, Honorable Ngubane.
Thank you very much, Chair, and good morning to everyone. I think from my side, Chair, we welcome the presentation and appreciate it. And as well, we appreciate the communication by the Minister that there is a decreasing number of litigations within the department. So, and then we really appreciate this. This is very important because some people outside here are now calling this Department of Litigations. So we really appreciate if there is a focused work on this department to decrease this litigation that are infested in this department. And let's hope that as well the achievement on this will be accorded as well to the increased efficiency and compensation and focus on the department and not being opportunistic. I think, Chair, on that one, on the collaboration between the DHA and the DSD, the challenge again, Chair, as we mentioned before, with this on this item, is our constitution. The Minister has stipulated quite correctly that the Department of Home Affairs litigation exists because we were not aligned to our acts or bill or legislations with the Constitution. So let's hope that mostly our officials in the department will focus at each and every time when they start to develop these acts, they make sure that each and every act must be aligned with the Constitution, because all the time these litigations increase because we just draft legislation without looking at what the alignment with other acts or laws, even basic things with other with Constitution. So what we'd like to know as well on this is how much have we spent on cases, state legal funded cases, through Legal Aid Board in representing the undocumented foreign nationals or presenting them in courts. So that's important to know that, Chair, so that we know how much are we wasting in managing these things as a country. Again, Chair, we thanks as well the Minister for finally coming to the committee. We were sincerely worried, Chair, about the accountability and the moral standing to the people of South Africa, because we had many lingering issues that we wanted answers on, but now we can't just boggled to the department's official asking them these questions. There are many this department, Home Affairs, that it is dealing with. What we'd like to know as well is that the Minister must take us into confidence, Chair, especially with the issue of Phil Craig, because we see things flying around on social media and we're not being addressed as a committee. The Minister must take us into confidence that, and we see letters going around. And then the Minister must take us into confidence as well with the Concord findings on the citizenships of the so-called 1.4 million individuals who will now have a dual citizens, as well as the challenge of not challenging this issue with the Home Affairs, because we know from the history that all the time this was an issue between the DA and the Home Affairs Minister. So we want as well, Minister, to take us into confidence on that it was good that these things was not argued in court, that the Home Affairs was justified that it must not go argue this court, because all the history of the department, the Minister has always presented the department when this case was sitting. In this department, Chair, most of the things, it's like it's the tail wagging the dog when it comes to matters of litigations. It tells you the story of incapacitation and then that it has no knowledge of law compliance when drafting the laws or the act. So as I said in the beginning, we need to improve on these things, because we are now a joke. Each and every time people will take this department into court and then we'll find one thing, which means everything we're drafting, we didn't know what we're doing. So this worries us in terms of this, Chair. if Minister was not here on our last meeting, Minister, we requested a report on the profiling or the stats of data of the so-called 1.4 or 2 million individuals who will benefit on the Concord ruling citizenships. Because we would like to know that the excitement behind these things, so that we know that there is honesty and trust in deliverables of this justifiable win by the Department of this Citizenship Act. And I think that's all from my side, Chair. But mainly, we are asking the Minister not to be excited about mountains, but please put your house in order on the basic things like capacitation, competency, efficiency, and corruption cleaning to the sections in the department that investigate corruption. We need to focus on the basics here before we become excited about big issues of modernization and digitization when there's still an incapacitation of our staff, easy takes that we're supposed to just put in order. I think in that nutshell, Chair, for now, that's my contribution to the conversation. Thank you.
Thank you, Honorable Ngubane. Honorable Ngoweni.
Thank you, Chair, and good morning, colleagues. Colleagues, this issue of undocumented children is really a powder keg. If you go to some of the cases that we receive, for example, one doesn't think about the unintended consequences of having had a migration system that has really been defunct for a lot of years. You don't think about what happens to some of these children when they die. For example, the collaboration between DHA and social development, when it comes to indigent children, of one parent being South African, the other being a foreign national, of course, the burden always lies on the mother in terms of how the child follows, particularly in cases where people are not married. I just want to get a sense as to what happens in an indigent situation where a child may pass away. For example, there is a child that I was dealing with this week who passed away and is an indigent child whose father is South African. The mother is a foreign national. What do we do in those cases? Do we just leave them into the ether, when there's no assistance? I'd like to get clarity on that kind of a situation. The other question, comment I want to make is with regards to tracking of undocumented persons. I think we really mustn't use these terminologies loosely. Some people are illegal and some people are undocumented, depending on how they got here in the first place. I want to get a sense from the minister. How are we doing in terms of tracking these folks if in fact people don't have documents? Because we get a lot of questions around, do we even have a sense or a handle on how many of these people are within the society? Is there a plan to deal with this issue? Because it's something that if it's left to fester, it's going to cause us even more problems than what we have currently. And then if I can come to the cases of, I want to echo some of what my colleagues have said. With regards to Phil Craig, we've written a letter of complaint. I remember the DM in the last meeting saying there was no complaint in this regard. We have since submitted that letter of complaint. I hope the minister has received it, and I hope to receive a response very soon, or we can get it even in this meeting. And then when it comes to these cases, against the DHA, given that several amendments to the Immigration and Refugees Acts, what are the prospects of having a more substantial amendment that's going to be aligned with the broader white paper on citizenship and migration? The other question that has really, of course, been in the public discourse of late is the Omotosho question. Why is the DHA of the view that the magistrate was wrong in the ruling on the matter of Omotosho? And also, can we just clarify what is going on with Omotosho? The media reports have been so confusing. He's gone now, of course. He's gone home, and we're saying we want to extradite him back to face the music. Can we please get clarity on how that entire process is going to be handled? On the issue of IDs, how many of blocked IDs remain to be considered by next year in terms of the issue of IDs is also a big matter in this country. We've got children who have matriculated and they did not have documentation, and now they're roaming the streets and they are literally nameless. I don't want to say stateless, but they're nameless. And we get a lot of requests from young people who need documentation. They don't have documentation. Parents have died, or whoever can sign for them. What happens in a situation like that in terms of getting people documented? And then what are the dates of the correspondence and expected outcomes on the Thabo Bester and Annabelle Rungo cases? And then finally, can we get a sense of the status of the ZDP holders after the High Court ruling of 2 years ago, whether it will be appealed or not? I know Honorable Mukhale asked this question, and I echo it. If we can get a response on that, thank you, Chair.
Thank you very much, honorable members, for your contributions. I've noted all the issues that members have raised, and I'm covered broadly. There are two issues which I think we may need to come back, and I think it's recurring on the to brief the committee on the stats of the undocumented children that are apprehended. And I think if we can briefly report to the committee, particularly on the 2024-2025 financial year, so that we're able to have a clear picture in terms of the issues that we're dealing with. The second point is on the cost of litigation. I think Honorable Ross also raised it. It will be important that we get a breakdown on the actual figures. And I want to check whether it does not impact or how it impacts to the work of the department in terms of the budget, but also in relation to the capacity within that unit of a legal unit. What is the capacity level in terms of the workforce? As you know, that observation is that a lot of cases that have been grounded off, that have been put across by the department, we may need to get a sense as to what is the strength of the personnel and the shortcomings that are being identified by the department. I think also the Omotoso matter, perhaps the department may also to, if there are no other cases that are related to this Omotos, except the enforcement that has been put for him to depart from the council. I think that is also the issue that we may need to get a detailed brief. The last one, I think Minister, the DM, and the DG, is evident that the white paper on citizenship, migration, and the Protection of Refugees Act, it may need, the bill may need to be fast-tracked in terms of the process that at your level you are taking. And I think we may need to collectively, ourselves and the committee, make sure that we realize this, because most of the issues that have been put across in relation to this subject matter are also residing within that white paper. And I think we may welcome the initiative that there are some of the issues that you will deposit there in terms of this presentation that have been presented. I will invite Mr. Simon and then Advocate Malekate, DG, the DM, and the Minister to comment on the response, on the issues that members of the committee have raised. Mr. Simons?
Thank you very much, Honorable Chairperson, and for the questions, Honorable members. Chairperson, let me start with Honorable Mukhali on which countries we are and the statistics on undocumented children, Chair. So I'll take your way forward on this, Chair, that we'll come back with the statistics, detailed statistics for the 24-25 financial year on the number of undocumented children in that regard. I did get the information that it's mostly Mozambican children, Chair, but let me rather come back and let us come back with the detailed statistics in that regard. With regards to the undocumented children and them pursuing their studies, etc., Chair, the Department of Home Affairs do not arrest or detain children, whether it's foreign children or South African children, for whatever reason, or undocumented minors, let me put it that way, Chair. So, as indicated, they are handed over to the Department of Social Development. The Social Development Department will appoint a social worker to take care of that case, that particular individual. And they are best suited to come here, Chair, and probably come with a report on how they deal with undocumented children, but also, as the later question from Honorable Ngubeni about children, late registration, South African children, undocumented children, and their role that they play there, Chair. But the social workers, of course, would look at the interests of the child, the rights of the child, place them either in foster care or places of safety, ensure that education continues, etc., Chair. But just to emphasize that as a Home Affairs Department, we do not detain children, Chair. When it comes to, Chair, the question from Honorable Ngubani about the Legal Aid Board, again there, Chair, the Department of Justice and Constitutional Development would be best placed to indicate how much we spend on legal aid, the Legal Aid Board on these cases that's referred to them, Chair. DHA is not involved in that whatsoever. Then in terms of the question of Honorable Ngubeni, in terms of the indigent child, so let me state up front also, Chair, that if one of the parents is a South African, the child will be registered with the details of that South African parent, Chair. So when it comes to indigent children and the caring and assistance for indigent children, the burials, etc., that's again a matter for the Department of Social Development that they would also can come to the portfolio committee and unpack a bit deeper how they do provide assistance. How we collaborate with the Department of Social Development, Chair, with even with South African children, we assist with the documenting of them, whether through the late registration of birth process or the process of acquiring documents through embassies, etc., Chair. That collaboration is still very important for us, and it is existing, Chair. Chair, that is the three questions that I picked up in terms of the first presentation. Thank you very much, Chairperson and members.
Thank you, Advocate Malekate.
Thank you, Chair. I think when I've got two questions, and the one that I would need to deal with is from Honorable Ross in relation to whether or not these parents can come and apply for permanent residence. And indeed, currently the law does allow for that, provided that they would have remained in the Republic of South Africa for the period that is that is required for one to apply for permanent residence. So if then it means that what the impact of the judgment is that these parents either at the end, you recall that they were issued a relatives visa or a visitor's visa on the basis of the relationship that they have with a South African spouse or a permanent resident spouse. When that relationship ends, the law as it was then would require them to depart from the Republic and then apply for another visa outside of the Republic. So the impact then is that now they don't need to go out of the Republic. They would apply for another visa on the basis, either on the basis of the child, but they need to prove that they are the parent, that they are taking care of the child, that if they are not currently taking care of the child, they must demonstrate an intention to do so, and then they would then apply. And if they are issued with that particular visa and they meet the requirements to apply for permanent residency, they would then apply, and the department would look at the application and decide on whether or not to issue the permanent residency. But there's no bar for them. The second issue, Chair, that I would need to deal with, it's from Honorable Ngobeni, relating to whether or not we should not be taking care of or coming up with a piece of legislation that takes into account the white paper. That is the intention, Honorable, that once we have finalized the work that we need to deal with in the supplementary work, and once everything is done, there has to be a legislation that is developed to take care of what the policy, the white paper would have indicated, the policy intervention. And what we are envisaging is that we want to come up with a piece of legislation that it would deal with the various chapters. One chapter must deal with the immigration, the second must deal with refugees up until citizenship, and ensure that when we do so, we are aligned to what the minister had indicated in the opening remarks, that we are aligned to the rule of law, that the provisions are constitutionally sound and will be able to stand constitutional muster, but all in all take care of all the issues that needs to be taken care of. Chair, and if you would allow me, and if Director General can also allow me, just to indicate, there's a question that comes from Honorable, I think it's Honorable Ngobeni, who asked a question that says, why is it that the department thinks that the magistrate in the Omotoso judgment was incorrect? Chair, just from our side as legal service, just to indicate that when we go back to the Lawyers for Human Rights judgment, both the judgment that was issued in 2017 and the judgment that was issued in the ex parte application by the Minister of Home Affairs, you would realize there, Honorable Ngobeni, that the court had indicated that the department must comply with Section 35 of the Constitution. And one of the requirements for that is that once we have arrested a person for purposes of deportation, we must bring that person before court within 48 hours of the arrest. The key issue that follows is that if the 48 hours falls outside of the normal court days, that person must be brought immediately before the court on the next available court date. So if you look at what had then transpired, and I think DG would also come in and augment what I'm going to say, but I just needed to deal with it from the legal side. That the 48 hours, we start counting. If a person is arrested at 6 o'clock, for instance, on Friday, so we start counting from 7 o'clock up until the 48 hours has lapsed. So if you look at the circumstances that followed there, we have the view that the magistrate was had in that judgment, in that one, the department was still within the 48 hours as it comes out from the two judgment, and also as enjoined by section 35 of the Constitution. Secondly, that even if you were outside of the normal court, outside of the 48 hours rule, the law says if a person is arrested, say for instance on Saturday, the next available court date will be on Monday. And when we look at that, then it means we are still within the provision. So that's why we are saying, Honorable Ngobeni, that the magistrate has erred in that the magistrate did not take into consideration or did not take into account the Constitutional Court judgment in that manner, in as far as it relates to the quantification and calculation of the hours that a person must be brought before court. Thank you.
Thank you very much, Advocate Malikate. Director General.
Well, thank you very much, Chair, and the honorable members for the questions that were posed. Maybe just to emphasize the issue that Advocate Malakate has raised based on Section 34, in particular number 2, that speaks to, I'm starting to deal with the issue around the questions that Honorable Mohale and Honorable Ngubane raised with regards to Omotosho. There were two issues that we are of the view that the magistrate Kevin von Brandt misdirected himself. The first one is what Advocate Malakate stated, that the person has to appear within 48 hours, or as it states here, on the next day. And it specifically states on 2 that that period will be extended up to 4 p.m. of the first following court day. And we are of the view that that arrest was still within the confines in terms of the legislation. The second area, Chair, where we believe that the magistrate misdirected himself was with regards to indicating that Mr. Omotosho still had an opportunity to appeal to the DG. You'll recall this was a minister's decision, which his lawyers had asked for. The minister had reconsidered that decision and therefore made a final decision, taking into consideration that his other visas had already been rejected. And therefore, a final decision by the minister cannot be remitted back to the DG. So those are the two issues. But with that aside, you will recall that this was a JCPS-led operation, and the priority in terms of what JCPS had agreed to was that Mr. Omotosho should be deported. And to that extent, our minister then wrote to the Minister of Justice, specifically asking if the NPA intended to appeal that decision. Safe to say that I think we only got a response after we all were almost in court. But the decision by the NPA, it's an independent entity for sure, Chair. They can be asked to come and appear before this committee and explain their rationale in terms of appealing. But what we do know is that it does not stop them from appealing, even if Mr. Omotosho is outside the country. That's on the Omotosho matter. On the issues related to Honorable Mohale, I think you asked a question around the Mazubuko ruling and the Annabella Rungo. Chairperson, we did submit a report. Unfortunately, I don't think it's on your agenda for today, but we were requested to provide a report on how we are dealing with all these cases. We've shared that report with Mr. Matonzi, and I think if there are other areas that the committee is of the view that we need to come and speak to, we can certainly do that, but that report has been shared. Safe to say, Honorable Ngobeni, on the blocked IDs, we started at 2.5 million, and then we've been able to reduce that number substantially to about 388,657. And specifically, Mr. Skamed indicated that about 112,967 relates to illegal immigrants, which require us to pay special attention to. which is what we are doing. And then the others are matters that are still under investigation. And I think at an opportune time, we can come and brief the committee. We have been given a further 24 months to remedy what we need to remedy in terms of that judgment. And that's what we are currently doing. And then I think with regards to the questions that were raised by Honorable Ross, I think the Minister will deal with the issue around the white paper. I think has already indicated that I think Advocate Malakate has responded to the Raymond judgment. I think Honorable Ngubane, the issues that you are raising with regards to the white paper, the white paper seeks exactly to deal with that. On one hand, we've got international obligations that we've committed to. And then on one hand, we have a constitution that mirrors those obligations. And therefore, we need to tread very carefully in terms of how we execute. And the reason why we started the process with regards to the white paper was the very same fact that there were areas that were in conflict with one another in the various pieces of legislation, whether it's in the refugee space or in the immigration space. And therefore, we were of the view that the white paper will remain of the view that the white paper will remedy this. With regards to questions that were raised around the capacity of the legal department, I think, Chair, you raised those issues. You will recall that a few years ago in the 6th administration, this committee visited the department to look at the capacity of the legal department. We have actually started, or we had started then, to recruit. I think fortunately we were given at least 11 positions which we filled of senior admin officers. And unfortunately, we've also had a number of resignations, and the majority of them are being recruited by the Department of Justice. The former director has moved to that department as chief director, and similarly, director litigation has moved to the Department of Justice. Obviously, we can't stop people from pursuing their careers. But the good news is that we've just concluded with the recruitment of a chief director, legal services, who will need to capacitate that unit, which means in the next few months, we'll then need to start looking at that. I think the other issues I'll then leave for the Minister to address, and the DM. Thank you so much, Chair.
Thank you very much, DG. Before the DM and the Minister, I see there's a follow-up hand. Honorable Ngobeni.
Thank you, Chair. I wanted maybe if just to come in case the Minister is the one who's going to clarify the question. I think the question that we asked on Omotosho, for example, it was not sufficiently dealt with. The process as it stands with regards to my question around the magistrate's decision is fine. I think that's clear. What is unclear is now that he's out of the country, we do understand that one can be prosecuted in absentia, but the minister's letter says the man is banned from coming back here for 5 years. Can we clarify what that looks like in terms of extradition? Because that's also in the offing. I just want clarity on that because that's not clear. And this is an issue of national interest, as you all know. The guy has gotten away scot-free on technicalities, and so we don't want that to remain. The other one on the issue around the assistance of indigent children. People are not getting assisted. It sounds good on paper, what is being said. I want to get clarity as to whether, do we still favor the mother over the father? So I'm talking about a case that is a live case as we speak right now, with a child who has died, whose father is South African, whose mother is not South African, and they were struggling to get this child registered after they died. Of course, they got documentation, but DSD was not able to assist them. I want to get a sense as to whether the response to that question is that this committee must summon DSD to come and answer those types of questions, and that this this forum is not able to provide clarity in that regard. I just need clarity with that, and I hope that the minister will come back on the Phil Craig issue as well, so we don't leave that behind, because that's one of the questions that was not responded to. Thank you very much.
Thank you very much. Let me ask the DG to exhaust some of the issues. DG.
Oh, thanks, Chair, and thanks, Honorable Gobeni, for those questions. I think with regards to the indigent children, Mr. Simons did indicate that we have a very close working relationship with DSD. I think it will be important to get details about this specific case and look at how we can assist. There has been cases like this before, and I think through that working relationship that we have with the Department of Social Development, we should be able to assist these children that the Honorable Member is referring to. I think with regards to the Omotosho matter, you will recall, the Honorable Member, that if the NPA and appeals do take a bit of time, if they are successful, at whatever time that they might be successful, the minister, in terms of powers that are in the Immigration Act, is able to waive any person who's been declared undesirable. In this case, it will be for that person to come and face the charges that they might be brought into the country for. And I think we do have a very good relationship with Nigeria through the extradition agreement that has been signed by DERCO with the Republic of Nigeria. Thank you, Chair.
I see, Honorable, can I check if there's any other follow-up before, so that we conclude this item? Okay, this follow-up is the last follow-up from Honorable Makhale. Honorable Makhale?
Yes, thank you very much, Chair. I think just two issues, fella. The issue about the ZEPs was not responded to. I didn't hear any response with regards to the ZEPs. So I think we also need some sort of a response, or get a report on that probably in the next meeting, so that we're able to be updated as members of the committee. And also on the issue of the Phil Craig matter, Chairperson, I also want to, before the minister comes in, to emphasize that we want to know, Chair, when or why is Section 30 of the Immigration Act not being invoked on Mr. Phil Craig? They've declared Omotoso a prohibited person and undesirable in terms of that section. Why is Phil Craig not being dealt with in the same manner? So those are some of the questions that when the minister comes in, he must respond to. Thank you, Chair.
Chair.
Thank you, Honorable DG. Then invite the DM and the minister.
No, thanks, Honorable Mokhale. With regards to the ZEP matter, Honorable Mokhale, you'll recall that the High Court in Pretoria had indicated that this matter is being remitted back to the minister to do the following. One was to consult with those affected ZEP holders in line with our PAJA provisions. And to that extent, the minister has taken a step further by appointing the IEB board, which is the Immigration Advisory Board. It's already, they've already started working. And in the letter that the minister has written to them, the minister has, amongst others, requested them to provide advice with regards to the ZEP, but also to do consultations with those affected members or those that are in possession of the ZEP. The matter is currently before the Supreme Court of Appeals, and on Monday, yesterday, we actually filed a supplementary affidavit to confirm that the IEB board has been appointed, and it's led by former DG, Mr. Mavuso Msimang, and comprises a number of people that have various skills, legal, and so on and so forth. And they are meeting again, I think, on the 5th of June, amongst others, to consider this matter, which we have confirmed to the court that the consultations are ongoing, led by an independent advisory board. Thank you, Chair.
Thank you very much, DG. Deputy Minister.
No, thank you very much, Chairperson, and greetings to yourself, Chair, and the members of the Portfolio Committee. I just want to venture into the issue of the registration of children. Firstly, just to indicate that for foreign national children, those who are born of foreign nationals, both mother and the father, we do issue a notice of birth, and the onus is on the parents to then go to the necessary embassy to then register the child on the National Population Register where the child's nationality belongs to. We often do have difficulties where there is an assumption that once a child is born within the borders of South Africa, therefore that child automatically becomes a South African citizen, whereas it's only out of the birth of one of the parents who must be a South African citizen. You will also know, Chair, that fathers now have a responsibility and the right to register their children, and as such, there shouldn't be a father who's turned away on the basis that they are the father and therefore the mother has more rights to register the child. The father alone can register the child. If the father is a South African, the father should be able to register the child. The difficulty comes when the child is now being registered outside of the legal provisions, which is like late birth registration, and that means that paternity tests have to be taken. And I suspect that in the case of Honorable Ngobeni, that might be the issue, where actually the father now has to do a paternity test, which of course it is expensive. It is being done by the Department of Health. When discussions with the Department of Health in terms of making arrangements for indigent people, as we are saying, and fathers to be able to get those test results for free, the engagements are still continuing with the Department of Health. Well, they are raising financial constraints due to the price it takes for those paternity tests to be made. One of the things that we're doing as we're building towards a digital home affairs is the e-birth module that will soon make available, which will allow us to register births electronically, which means we will no longer have to deal with quite a lot of paper that is currently cumbersome. That we believe will also help us with the registration of births for foreign nationals, and then we keep separate databases so that there are records of birth that they can use when they go to their own embassies. But all in all, fathers have a responsibility. They can register their children. I suspect in the case in question, it is an issue of getting the paternity results and the parents not being able to afford, which I think we can deal with it with the Department of Health. But we are on engagement with them over the overall situation on how we treat indigent cases. Thank you.
Thank you, TM. Minister.
Thank you very much, Honourable Chair, and to the honourable members for those questions and comments. Thank you also to the Deputy Minister, the DG and the team for dealing with a range of issues. Let me come in on some of those other outstanding matters then, Chair. I think let me start with what you have recommended in terms of additional presentations. I think those can be done. The issue of litigation costs, etc. I think there will be another presentation here today showing some of the numbers of cases, but I do think the costs are declining in a commensurate way. So I think that is something that we should look at. Yes, I think the issue of undocumented children, I'll also just touch on that later, but clearly an issue that we need to look at as we move forward. Chair, let me start with the first point that was raised by Honourable Ngubane. I think he made the point that legislation and really our actions should be aligned with the Constitution so that we avoid the kinds of costs and issues that we are dealing with here today. I think that is exactly what we are trying to do. And I think some of the progress is now visible at the high level, but it is always something that is an ongoing principle that we have to enforce as we move through the legal challenges that we face. I do agree with the members' inputs and observations on the long history of litigation against this department. It really is an extraordinary challenge because it effectively means that in some cases we spend so much energy in court when we should be out in communities servicing the people. And so that's why this really is a matter of service delivery as well. It's not only an abstract issue about litigation. It is making sure that we are on the right side of the Constitution and the law so that we can actually spend our time and energy on the things that are directly relevant to community. So I thank the colleagues or the members for the acknowledgement of the progress on this, but certainly we understand that there's a lot more that we still need to do. Chair, the issue of the 1.4 million naturalized citizens and permanent residents who have gained access to smart IDs, I would just like to clarify that that should not be conflated with the Constitutional Court judgment on South Africans who have lost their citizenship unconstitutionally. Those are two entirely separate issues, and I think it's good to just perhaps clarify briefly on this. The Court judgment dealt with South Africans who had left the country and then automatically lost their South African citizenship when they assumed another citizenship, and the Court unanimously found that that was unconstitutional, the automatic operation of this, and the requirement that it needed basically approval from the minister before someone could retain their citizenship. So that is a clearly settled matter in court, and I would also be very clear in saying if we are going to be serious when we talk about reducing court losses and reducing the money and time spent in court, then we cannot oppose cases where we have no prospect of success. And clearly, the unanimous and strongly worded Constitutional Court judgment showed that we made absolutely the right call in not spending more money on a case that, on the merits, was going to be settled in this way. So that, I think, is the one issue. But the second part, and as I say, this is a completely separate point, I will welcome the opportunity to just briefly touch on this as it relates to this smart ID issue. Now, I think, members, it's really important to always take it back to what we're trying to achieve. One of the critical things that we are trying to achieve is to combat identity fraud and identity theft. And if you look at where that is perpetrated, how it is perpetrated, you'll find that the biggest source relates to the continued use of the green ID book, the green barcoded ID. There have been independent studies on this showing most recently from Smile ID, I think is the name of the organization, who does an annual report on fraud and identity theft. And they showed that the green ID book is 500% more vulnerable to fraud than the smart ID. And so the big picture here is that if we are going to deal with identity theft and the massive leakages and fraud and financial impact that it has on our country, then we have to move away from the green ID book because of how vulnerable it is to fraud. It's a very manual paper document that can be manipulated. So that's the big picture of where we're trying to go. Now, in order to get there, we obviously have to make sure that the 18 million people who still have the green ID book are able to get the alternative. Again, we will lose in court. We will create problems for ourselves if we just wake up one day and say the green ID book is no longer valid, because people will go to court and say, I have been deprived of my ID and I don't have the option of getting the alternative. So that's what we need to deal with. Now, there are two areas where people are or have been prevented from getting the smart ID. The first one relates to non-modernized Home Affairs officers. I'm sure all honorable members are aware of this challenge. that there are still about 100 Home Affairs offices that do not offer the smart ID. So in areas where people cannot obtain the smart ID, it would not be reasonable for us to say, well, now you can't use your green ID book. We first have to make it possible for those people in those communities to get the alternative, the more secure alternative. So that is one aspect, and we continue to work on that. And we are building on the successful pilot project where Home Affairs services are rendered in some bank branches. We want to make certain IT reforms that will massively expand that so that every community in South Africa is able to get the smart ID. That's the first one. The second one is this issue of naturalized citizens and permanent residents. Until last week, they were blocked by the IT system from being able to obtain smart IDs. So in effect, these individuals were being forced, even though they are legally entitled to South African identification documents, they were being forced to get the more insecure green ID book. It makes absolutely no sense for us to say, on the one hand, we want to do away with identity theft and fraud, and we want to therefore do away with the green ID book, but then on the other hand, continue to produce the green ID, and even worse, force certain people only to get the green ID book. So this is the second issue that we have now addressed, and we continue to address, whereby we are enabling everyone who is legally entitled to an ID document in South Africa to get the smart ID. And that rollout is now underway. We've started with a risk-based approach to this. So we've started with visa-exempt countries and people who already have the green ID book, because then we can do the biometrics and the verification and actually filter people who should not have the green ID book and make sure everyone who gets the smart ID is entitled to it. So, honorable members, this is going to be a very, very important step forward for the country, because we are moving in a very focused way now to using technology to make sure that everyone has access to the more secure ID document. And it is at that stage, once that has been achieved, both through expanding access, but also through including people who are legally entitled to getting the IDs, that we will then have enough space to be able to say we're moving away from the green ID book. Of course, all of this also is going to help us deliver on the digital ID drive. Members will have noted, I think, the announcement of the digital transformation roadmap. The president made this announcement in the State of the Nation address. And essentially, the roadmap is get away from green ID books, get people into the smart ID, and then graduate into a digital ID where you're able to have a secure, not only ID document on a smart device, but the ability to authenticate yourself, to use your phone or some online system to confirm your identity. So, Chair, I thought it's just important to really clarify that those are two separate issues, and also to emphasize the enormous importance of the step we have now taken to roll out these documents to everyone who does qualify. Chair, let me then get to some of the specific cases. I think the Omatoso matter has been dealt with to a large extent. All I would really add is to say that our door is open to the National Prosecuting Authority to work with them if there are further developments. We have a mandate, obviously. When someone is illegally in the country, we cannot turn a blind eye. We cannot, sit around when we have that information. We have to act, and that is what we did in this particular case. And yes, there are complexities, but our door is open to working with our colleagues should there be a need for extradition or anything further down the line. On the Phil Craig matter, I think it's important here to also just clarify that there has been a bit of confusion around whether there's an application for citizenship. So there is no such application for naturalization or for citizenship by this individual. And so that's where some of the difficulty comes, because we're having a hypothetical conversation about an application that does not exist. I have to indicate to members that it's both this individual and another one that has been raised. Mehmet Vefa Dag, I think, is the individual's names. These are both people who are politically active, who have not been born in South Africa. And there are people who have raised concerns about this. In the case of Mr. Dag, he is a naturalized citizen, so he's already become a South African citizen. In the case of Phil Craig, there is no application for citizenship before the department, and he is a permanent resident. So that's the first point, just to address both of those cases. And then, of course, Chair, we have to look at, again, as I've said throughout the meeting today, we have to look at what is the legal foundation when we address the concerns around some of these individuals. I think, and I must make this observation, that these are individuals who are from, I would say, two different sides of the political spectrum, and there are people who are upset about both of their conduct and the kind of political messages that they are sending out into the world. But it is very important to make this point, that South Africans, as well as everyone who lives in our country, as our constitution makes absolutely clear, it uses the word everyone, has the right to freedom of speech and has the right to advocate for certain views. Of course, the difference is that a non-citizen is not allowed to vote, and that is a distinction that is relevant here. So in terms of where we are and the way forward, there is no application from Phil Craig for citizenship, but I'm very happy to indicate that if we depersonalize it, we have to ask this question: can someone who wants to partition a country, who effectively does not believe that a country should be constituted in terms of our constitution, qualify for citizenship? And I ask this as an abstract question, not about an individual. And I think it would be a very difficult thing to satisfy. And especially if you look at the Citizenship Act, which says that, I think it's section 5(1)(g), that a person who wants to be naturalized has to have adequate knowledge of the responsibilities and privileges of South African citizenship. And so that is the question that we would have to engage if there were an application from this individual. But I can tell you very, very directly today that I think, abstractly speaking, someone who doesn't want a country to exist is going to struggle to justify that threshold. Having said that, there is no specific application, and we will obviously consider applications on their specific merits. As it relates to both of these individuals and their current status, so as I said, the one is a naturalized citizen, the other is a permanent resident. My view here is very clear, and I've indicated this repeatedly, that we will not use the citizenship laws of this country to settle political scores. If people are making arguments, whether it is on one side of the spectrum or on the other side, that we disagree with, well, they have the freedom of speech in our constitution, as long as it's not hate speech, and we must go and defeat their arguments and make better arguments. That is, I think, clear from the legal advice that we are engaging with and continue to engage with, that you cannot abuse arbitrarily power to punish people for political speech. That we will not do, because precisely for the fact that we'll end up back in court and with another problem on our hands. Chair, I think the other point I want to make is on the blocked IDs. And I think that it was Honorable Ngubeni who raised this issue. And I want to go broader to say it's the issue of the blocked IDs, but it's also the issue of undocumented children that has been raised very strongly by the committee today. And this is really where we need to get Home Affairs. We need to get Home Affairs to be able to go and deal with these burning issues that are out in communities. But at the moment, we are very much absorbed and constrained by the routine day-to-day work of the department. And it includes things like being in court too much. But it also is the fact that we are understaffed, and most critically, that we are forcing people to go to Home Affairs offices for these routine services. When I say routine, I mean renewing an ID or a passport or some of the certificates that people need. And what we are trying to do is to use technology to make that less of a burden for the department. So through the work that we're doing with expanding into more bank branches, for example, and getting onto the apps on smartphones, we'll be able to lift the burden on the department so that those routine transactions can be done remotely. People can get the documents delivered, And that will free up capacity in Home Affairs to finally really zoom in on these problems. And I want to agree very strongly with the members that this is a massive challenge, the issue of undocumented children, but also undocumented South Africans. We talk about undocumented as if it's one category, but there are millions of South Africans who are undocumented. And what we need to do is to really take the approach that India has taken. They are a country that shows what can be done, whereby they were able to go out into communities. And even if an entire community of people had many undocumented South Africans, you can engage with the neighbors, you can build the genealogies, and you can document people through a very sustained campaign to address this issue. And that is where we would like to get. But I will be honest with members, we can't get there under current circumstances because the department is just so inundated with these routine tasks. But the commitment would be certainly from our side that if we can succeed in using technology to take care of the more routine tasks, then we want to get Home Affairs to go out into communities and really focus in a very specific way on recording biometrics for people, on documenting South Africans, and making sure that we really start dealing with this sort of foundational problem that we have. Chair, finally, on the supplementary white paper, just to indicate that yes, indeed, we are making progress on that front. It will then go to Cabinet and it will go through that process of participation. I don't think personally that we will have to wait for 2030. I think we are moving more quickly than that. But we're also making sure that we have the best possible product, Chair. We are using the Immigration Advisory Board to also weigh in on making sure we get the best white paper out of this process. But I just want to emphasize, it's not like we're sitting around and doing nothing while the white paper goes through the process. Everything we are doing, including the things that I've spoken about now, are building the foundation to ensure that we can effectively implement the white paper. And I want to say to colleagues, we mustn't create the impression that by changing wording in a law, that is a silver bullet to solve a problem. It's not. It absolutely is not. And in fact, South Africans are quite tired of hearing that we're going to change a law and that this will solve problems, and then that law can't be properly implemented, or even worse, it's conflicting with the Constitution and it goes to court for years and actually you end up worse off. So we are building the foundation to make sure that we can effectively implement the legal reforms that are on the way through this process, but we're also making sure that those reforms are constitutionally compliant. So that is really the process, Chair. And as I say, I informally want to give the indication that I don't think it will be a matter of 2030, but we will obviously keep the committee posted to make sure we have the best product at the end of the day that can be effectively implemented by Home Affairs, that has a modernized administration, and can make sure we use technology to fulfill the kind of aims we will have through that white paper. Thank you very much, Chair.
Thank you very much, Minister, the DM, and the Director General. Let's deal with the two issues and we exhaust them. The first point on the white paper is that it was initiated by your team that it would be considered in 2030 in relation to the strategic plan, which was presented in the committee. And we argued strongly that that date must be reviewed. And I think you are familiar with the report, the brief that the committee was presented to. It's not an individual matter as you are using Minister. So it's important that when you interface with the document in the committee, at least you appreciate the content in which you brief the committee. So it's our resolve that the white paper and the supplementary process that you're undertaking should be within the time frame that the committee has directed the portfolio committee. And I think it's because of the changes that we seek to amend to resolve the current challenges that we're facing. It's incorrect to suggest that any law that, the narrative that we're contributing to, that it will seek to resolve these challenges that we're facing, because it's an amendment that must be processed by the portfolio committee and initiated given the challenges you have identified as the cabinet or the ministry since the sixth administration to date. Hence, you're also advancing the supplementary matters before the white paper. And I think that is the spirit in which all of us, we ought to understand. We'll appreciate that resolve collectively with the portfolio committee and yourself. We take note to that. In fact, even the presentation you've received today talks to those issues in relation to the white paper. The second one is on the matter of the Phil Craig. And I think you are grounding your argument in relation to the legal advice. And I think you're formulating a foundation to that extent. And we have resolved that we're going to pursue this subject matter on the Phil Craig, including his conduct, because it's not a matter of the committee. But these are the issues that arise from the members of the public in terms of his attitude and in terms of our articulation within the framework which you've referred, the Constitution of the Republic. So we've sought the legal advice also from Parliament on how we must respond to this question. And that is the resolve. It's not a matter of the personal engagement between the minister and the committee, but it's also the committee that it ought to satisfy its oversight processes in relation to all the matters that we stick to. So we'll respond to that question within the foundation that you have already argued in that spirit. We appreciate the report. At least there's a movement in terms of the process that was undertaken by the department and also the presentation that was made by both your team, Advocate Malekate, and also Mr. Simons. What is left is to also update the committee on the litigation costs that all of us were identifying, and also the statistics in relation to undocumented children that have been apprehended within the financial year 2024 and 2025, so that we get a sense as to the work that they have been doing. And I think taking a point from members that we may need also to consider to engage with the Department of Social Development or the portfolio committee that deals with the social development around this question of and how they administer the process of the undocumented children. Members, I think this is our noting in relation to all the issues, including the Omotoso that has been briefly being dealt with. In our next session, also will request Minister that relates to this Wi-Fi matter that is on the public discourse. And I think we'll get a detailed report from the DG. And yourself in our next engagement will formally communicate what is an expectation around that, so that we don't get issues and ought to respond as a portfolio committee, but at least to satisfy clarity in terms of what we need to deal with. So that will be our summary on the two presentations on how we then move forward. I will consider the two hands are legacy hands. I'm not sure if there are hands that are related to the previous.
Are you recognizing us, Chair?
No, I thought it's a legacy hands.
No, it's not.
On the two issues.
Yeah, it's a follow. It's a question based on what the minister, or a comment based on what the minister has just said.
Okay. I will give you members on the issues. Because we thought that we've closed on the matter and the process is outlined how we're going to deal with the outstanding matters and also the response of the minister on the issue. I may not assume what issues you want to raise. Honorable Makhale?
All right. No, thanks very much, Chair. No, Chairperson, I want to register my disappointment on the minister, particularly on the issue of Phil Craig. Chair, we have raised this issue very strongly in the committee. The minister has not been part of these meetings for the past 2 or 3 weeks, so he doesn't know what the deliberations and the engagement around that issue has been about. But this issue, Chairperson, I don't know, I don't understand why the minister is trying to, run away from it in a way, because he's trying to confuse the committee by now introducing another person that we have never discussed here on the platform, which is Mehmet. We don't know that person. We raised the issue of Phil Craig, and we felt very strong about it, that you can't have a person who's advocating for breaking up our country, who's here on a permanent residence and is allowed to roam around and do whatever he wants to do, and the law is not being invoked. They were able to invoke Section 30 of the Immigration Act on Omotoso. Omotoso is ran away. Why is the minister not doing the same thing on Phil Craig? He's saying to us, in essence, that they are waiting for him to apply for naturalization. Then once they get their application, then they will take those things into consideration. What are they doing now? Now as we speak. That's what we're interested in. Why is the law not being invoked now on that man? The minister agrees there. He says we can't have a person who's advocating for such things, whether such views will be allowed to get naturalization. The question is, why are they allowing him now? Thank you, Chair.
Okay, let me assist the members. I propose that we count our process summarized. One, we've deliberated on the matter. We receive a response from the minister. We've employed the legal services to come and advise the committee on how we must pursue and respond to that matter. And we're going to pursue that process. We've alluded on the issues that the minister has brought in the committee. And I think that's the first summary that we are going to deal with. I'm going to give Honorable Ngobeni and the minister will come back, but that is the position that I'm putting across. That is a resolve on the last portfolio committee meeting. And thereafter, the minister will then respond formally, because we ought to take this matter to a discussion between us and the minister, grounding ourselves within the legal framework that constitutes this process. Honorable Ngobeni.
Thank you very much, Chair. No, I will not go back to point number 3 or the last point that you raised, but I think it must be noted very strongly that we can't say it's not serious enough, the advocation that this individual is involved in. So I'm happy with that. But I wanted to also come in and say it's not always just doom and gloom. Of course, we must take the Phil Craig issue very seriously. But I do want to commend the department as well as the ministry on the work of the BMA during the Easter. So I think the demonstrations that some of these efforts that are being taken can be quite helpful in helping us mitigate some of the issues that we've been dealing with. And also, regardless of how the things may have panned out, the fact that we were decisive in taking action on Omotoso was also a very good step in the right direction. And so I think we need to be balanced in our commentary and give credit where it's due. So definitely we are satisfied with those types of developments. And so if we are really going to build this republic, we must be of the view that whatever happens in this country must advance the development of our state, and as well as its unity and its people to be able to deal with the challenges, because the divides and the divisions in our country are too grave for us to have others exacerbate them. And so I'm very glad, and I want to commend also the committee for saying that we are going to take the Phil Craig matter further. I think the people of South Africa need to know that we are doing something about it, because it's something that they do care about. Thank you, Chair.
Thank you. I see, Honorable, can I check any other member want to raise a hand before? Okay, it will be last hand, Honorable Ngubane, and then the minister. Then we close this item. Honorable Ngubane.
Yeah, Chair, my interest mainly that hasn't been clarified correctly, that the public in South Africa was up in arms when they hear this matter. Somehow, even, Chair, when we communicate these matters into public, we tend to inflame anger from the public, not taking the responsibility that now we're the custodian of the Home Affairs Department. We rule over all kinds of South Africa. Our excitement, sometimes it misleads us when there are these issues. Sometimes we get excited and we become partisan. So we need to desist from that. So my issue, Chair, yeah, I'm pleading, Chair. Can the minister take South African public into confidence about the 1.4 or 2 million Citizenship Act people that he has highlighted that they will have dual citizenship while they stay in London or in New York? They will be able to participate on electoral matters of South Africa. Even whoever who stays in London or New York can become a president of the South Africa. That alone has inflamed anger into South Africans. And somehow, I'm pleading, Chair, the minister must be careful not to become excited in such a way that he inflame people, that they become angry at us for unnecessary things. Now people are going, I don't want to extend this conversation now and say, people are saying this, people are saying this. There's a lot of unnecessary things that are not supposed to, if we can communicate this thing correctly. My conclusion was we request a profiling so that we can satisfy the public that with this Citizenship Act Concord finding, there are no nefarious means that the people now are perceiving in this department that this is what we're trying to achieve. What we've asked, we said we need a profile, a report, a stats report of all these 2 million citizenship that will have dual citizens, or all of it, no matter the circumstances or whatever they will get, so that the people of South Africa trust us as Home Affairs, that we don't do things to be partisan or to benefit other political parties over the other, or to even to make sure that this country is governed by another country while we stay in it. That's the emphasis on me, Chair, that I needed that pleading, that it needs to come out so that people in this country can trust us, that in this country we have their best interest at heart, as they are the taxpayers of this country, and they at the receiving end of each and every political decision that we take as South Africa. Thank you, Chair.
Thank you, Minister.
Thank you very much, Chair, and again for the comments. I think the comments by the Honourable Ngubeni are specifically appreciated, and I think that is exactly right. We will have different views on matters, but I think at the end of the day, we all want to move the country forward. So let me just briefly respond to those two additional issues. The first one by the Honourable Ngubane now about the Court judgment. Just to indicate again, I think I was trying to explain that those are two separate issues. The 1.4 million people who are getting smart IDs are people who live in South Africa, who are South African citizens or permanent residents, who previously only were able to get the green ID book, and that contributed to the problem of identity theft and fraud that we have because of the vulnerability of that document. And we have now enabled, and indeed we are extremely excited, because it is a blow against identity theft. I don't understand how we could not be excited about that. And we've done that by enabling people to get the more secure document. And I think that is the one issue. It has nothing to do with the Constitutional Court judgment on South Africans who have unlawfully lost their citizenship. But on that matter, there's really only one thing to say, Chair. The Constitutional Court has spoken. And we are a government that is guided in our statement of intent by adherence to the Constitution. There is a unanimous judgment by the highest court in the land, and it is the responsibility of every member who swore an oath to uphold the Constitution to respect that. That is what we are doing at Home Affairs. We respect the judgment. It was a clear case with a unanimous outcome, and we will now uphold our responsibilities in terms of what the court has said. And that is the essence of living in a constitutional democracy. You may not agree with everything that happens in courts, but you must respect and uphold that. Because the alternative is to attack the court, it is to undermine the Constitution, and that is to unleash a populist response that will ultimately threaten our democracy. And Home Affairs will have absolutely no part in such a response. This is our commitment, this is our oath, and we will uphold it. Chair, then on the issue of Phil Craig, just again to clarify, of course, I think it was the Honourable Mogale. Well, the answer as to why the Omatoso case was different is because he was in South Africa illegally. He was not, he did not possess legal status in the country. And when someone is illegally in South Africa, as the DG indicated earlier, then the Home Affairs mandate is very clear in terms of deportation, and especially when it is a case where there has been an overstay of thousands of days, I think, since there was legal status. It is crystal clear that when someone is illegally in the country, what the mandate and responsibility of the department is. That is, of course, very different from someone who holds legal status in South Africa and who is making speech or political pronouncements or positions that we may not like. But again, if we are going to be grounded in the Constitution, then we must respect the advice that we receive, and we must respect the freedom of speech that is the right of everyone in South Africa according to our Constitution. And so I hope that that clarifies, Chair, just the differentiation that's needed between these two cases. Where there's illegality, there is no question about it. Where someone obtains fraudulent documents, where someone overstays, there is no question we enforce the law. But where people hold legal status and take political positions, and that's why I illustrated the complaints that I get about some other political actors as well, it doesn't matter, what our view may be necessarily, and we may hold very strong views about some of the things that are being said. We must remain guided by the Constitution and what the law requires. Thank you very much for that opportunity, Chair.
No, thanks very much, Minister and the team. Members, I think there must not be a narrative that suggests that any view that is sought from this committee seeks to undermine the Constitution and the court's judgments towards Parliament or the department. And I think we must debunk that narrative. This committee and other committees have dealt with the judgments that arises from the Constitutional Court or the High Court. And I think that it must not arise that when we raise issues, we seek or don't respect the constitutions of the Republic. So I wanted to raise clearly, Minister, so that, and we continuously caution the line talk in terms of views expressed within the Constitution of the Republic. And I don't think there's any other member of Parliament that will seek to undermine the Constitutional Court judgment. And that is demonstrated by the amendments of legislation that are coming before Parliament or committees, including this one, that we continue to engage with. So we'll close this matter on the Phil Craig that will also sort a legal guidance from our parliamentary legal services on how we must pursue this matter and respond both to what you have said today, Minister, including the issues that are related that you have written to the committee. And secondly, Honorable Ngubane, I can get a sense that your matter is not sufficiently being reported. We'll deposit that matter again to the Independent Electoral Commission in terms of what does it mean in their process around this judgment of dual citizenship, so that there's clarity and accountability when we communicate to our people. It's an important question that we must pursue if the department is unable to categorically clearly respond to this matter. And I think both the IEC and the Minister will grapple with it to respond to the portfolio committee meeting. Then it will indicate that we've exhausted, and Minister, DM, DG, and your team, we again note and appreciate the improved work that has been done in relation to the presentation that we've received and the work that is continuously being conducted at the level of the department and all the officials that are grounding themselves to service our people and respond to the task that have been assigned to do on all the issues that we've highlighted in terms of the processing forward on the issues that we've account on summary will follow up as the members of the portfolio committee. We'll step off this item We'll invite Mr. Matonsi on the another item on immigration. Our understanding is that we've exhausted this matter in terms of how we're going to move forward. If there's any other issue that members want to raise, we'll then propose that we invite the Chief State Law Advisor in our next session to prepare the A list for members to interface with the or deliberate on that process. If there's any other matter members you want to raise in relation to immigration amendment bill, you can indicate, but my understanding is that we've now exhausted clarity on the issues and we await the Chief State Advisor to, in the next session, to brief the committee. Then we can move to the last item of the one-stop border posts. I don't think that we'll consider the minutes, Mr. Matonzi. We'll then defer them in our next committee meetings. Can I get indication on this item on the immigration bill, if this process we're undertaking, if there's any other matter that members want to raise before we get comfort to both the Chief State Law Advisor and the Parliamentary Legal Team. Members? Okay, it will appear that the process is being confirmed. Can I get indication from the Chief State Law Advisor if they're in the meeting?
As I indicated earlier, they are not in the meeting, but she will get the recording from YouTube.
Okay, so we'll invite them in the next, you'll inform them that they will proceed with the A list.
Yes, I will, Chair.
Okay, is there another matter? Parliamentary Legal Services?
Good morning, Chairperson. This is Daksha here. Chair, at our last meeting, you will recall that we raised certain questions for the committee to consider and to deliberate on, and then to also take certain decisions in respect of developing an A list. And unfortunately, the State Law Advisor will not be in a position to develop that A list unless the committee has taken decisions on amendments that they would like to see in the bill. Thank you, Chair.
Okay, noted. Members, I think there was a process that you've undertaken in our last committee meeting. Can I get comments on the matter that have been raised by Clara Williams? Oh, sorry, Daksha. I think they're together in the space there.
Thank you, Chair. Yes, we are sitting together in our office. Daksha already indicated her concerns. Thank you, Chair.
Okay. Can then I propose that, given that these responses and we have not been carried on, and also the content advisor, can I propose that we consider the decision on the issues that have been raised by the Parliamentary Legal Services on Tuesday, Mr. Matonzi? That will be the first item to consider this report, so that we allow the Chief State Advisor to proceed on the responses that could have been carried by the committee. Honorable
Thanks, Chair. No. I agree with your process. Mine for Daksha was just to check, because I would need to refresh my own memory with regards to the A list. What are our timelines in that regard? I may have missed that. If I can get clarity, thanks.
Okay, thank you, Daksha.
Chairperson, at this point, there are no timelines in terms of meeting any constitutional court judgment deadline. So our timelines are in line with your program, Chairperson. So I understand you to say that next week at the meeting on the 27th, those questions will be deliberated upon and the committee will take decisions, and then we will be instructed then to go and develop the A list and present the A list at the next meeting that will be scheduled. Thank you, Chair.
Okay, thanks very much. Let's firm up that decision that on Tuesday, members will go and work on your thoughts in relation to the response of the Parliamentary Legal Services. On Tuesday, we'll consider it and adopt or consider the issues that are arising on the responses of the parliamentary legal services, and then will then inform that will inform for the processing of the A list subject to the decision we could have taken. Can I get the seconder around the position you are taking?
Seconded, Chair.
Seconded.
Thank you. Can we then move to the last item, brief on the one stop border post bill. You recall, members, that it was tabled before Parliament by the Department of Home Affairs, and then it was subjected to the public comments or advertised for written submissions. And I think we've been able to interact with, we've requested the content advisor to brief the committee on the issues that are arising from this bill. And then members will comment and take a process forward. Mr. Salmon?
Thank you, Chairperson. Yes, so we received a total of 8 submissions on the bill. They were fairly substantive, but there weren't that many submissions. And what I've done is I've grouped the submissions according to the clauses that they relate to, and where they're similar, we've grouped them together. And then there are also some issues that aren't covered by the bill that are identified as omissions, which I'll deal with in the second section. So in terms of the first clause on definitions, the Office of the High Commissioner for Human Rights, Scalabrini Center, and South African Catholic Bishops' Conference recommended expanding the definition second section to include terms relevant to vulnerable groups, including asylum seeker, refugee, child, unaccompanied migrant, separated migrant child, a stateless person. OHCHR also suggested adding asylum seeker visa, and CPLO suggested definitions align with international protocols for consistency. And then lastly, the Consumer Goods Council of South Africa notes that the official use reference in clause 6 is also not defined. And in terms of clause 2, the OHCHR recommended expanding this clause, or to add a new one to include interpretation provisions, requiring the Act to be interpreted and applied consistently with international rights and refugee law instruments, such as the 1951 Refugee Convention, the 1961 AU Protocol, the 1967 Protocol to that convention, and the 1969 OAU Convention on Migration and Refugees, a Universal Declaration of Human Rights, and similar to the Section 1A of the Refugees Act. In terms of Clause 3, which relates to the establishment of a common control zone and a one-stop border posts, Scalabrini and the CPLO expressed concern about the broad powers granted to officials under the clause relating to arrest, search, seizure, and detention, without explicit reference to constitutional and international human rights safeguards. Scalabrini then recommended to amend Clause 3.1 to include reference to fundamental rights under Chapter 2 of the Constitution and South Africa's international law obligations, particularly relating to vulnerable groups. They also recommend adding a sub-provision to Clause 3C, authorizing officials to ensure the application of fundamental human rights and protection for vulnerable groups, such as asylum seekers, children, trafficking and torture survivors, and stateless persons. CPLO recommended that state officials exercising power under Clause 3 must ensure rigorous implementation of constitutional rights. Zach Desai, an individual submission, specified timelines and consultation processes for designating one-stop border posts and the common control zones to enhance transparency. And the Consumer Goods recommended Clause 3 to clearly stipulate that the minister in international agreement cannot exempt any official from the application of current South African laws. Clause 4 deals with the application of border law enforcement. Gustatu raised concerns that the bill is silent on specific roles and legislation mandates for the BMA, SARS, SAPS, SANDF, and within the one-stop border context. and propose inserting a clause reaffirming these legally binding roles to prevent usurpation of functions. For example, BMA taking over SARS' constitutional role. Scalabrini highlighted the lack of clarity regarding responsibility and potential for rights abuses, such as asylum seekers being bounced between officials in common control zone where laws of both states apply. They linked this to Clause 4's provision on an applicable law. Lawyers for Human Rights noted that while Clause 4 addresses the application of border enforcement laws, it doesn't adequately address the potential conflicts between the substantial laws of a republic and the adjoining state, particularly concerning human rights or treatment of migrants, so where the two countries' laws are different. Application of criminal law. Scalabrini recommended amending Clause 5 to refer to non-political criminal offences to align it with the refugee law principles which protect against return of political activists to countries where their lives may be in danger. And they note the dual jurisdiction framework may lead to enforcement conflicts where laws differ significantly, and recommend introducing a clear conflict resolution mechanism between countries. Zach Desai and LHR note the dual jurisdiction framework and the lack of procedures for resolving conflicts of law that may arise under this clause. And they're proposing sorting a new clause 5A detailing dispute resolution mechanisms, so similar to what was said above. Clause 6 deals with the free transfer of money or goods within the common control zone. The Consumer Goods Association strongly objected to this clause and argued that it grants officials, both South Africa and foreign, unfettered freedom to move money or goods across the border for undefined official use without accompanying any of the import, export, entry, or exit laws, including customs and exchange controls. They view this as a major loophole for corruption, money laundering, and illicit trade, especially given South Africa's Financial Action Task Force grey listing. And they note that similar legislation in the East African community of in Zambia and Zimbabwe is far more constrained or lacks such a provision entirely. They recommend removing Clause 6 in its entirety, and Zach Desai recommends adding measures to prevent the exploitation of this provision for illicit activities. Clause 7 relates to the obligation to readmit. Several submissions express significant concern that this clause undermines the principle of non-refoulement, that is, sending people back to countries where their life is in danger. Clause 7.1a allows for the state of entry to decline admission without exception for those seeking asylum. Clause 7.1b potentially allows for refoulement based solely on illegal entry, not entering by a designated port, contradicting international and South African refugee law and the 1951 Convention, and LHR notes this could apply beyond the common control zone. Clause 7.1c mandates readmission by the state of exit, potentially forcing the return of individuals to harm and preventing the exit state from taking protective measures. And they recommend Clause 7 to explicitly incorporate and be subject to the principles of non-refoulement, ensure protection for asylum seekers and stateless persons regardless of their method of entry, and reference relevant sections of the Refugees Act and international conventions. And Consumer Goods SA refutes Clause 7 as imposing an undue and potentially burdensome application on the state of exit, potentially creating operational challenges. And then we go to more general concerns, comments and admissions, not related to specific clauses. Overall objections on the preamble. And there we have Scalabrini, Cosatu, and the CPLO supporting the bill's objectives for improving efficiency, easing congestion, and boosting trade and tourism. But Scalabrini recommend adding combating corruption and protecting fundamental human rights in terms of Section 2 of the Constitution to the aims of the preamble. Then Tato Seleke and Zak Desai recommend amending the preamble to explicitly reference regional international obligations and frameworks like the SADC Protocol on Trade and African Continental Free Trade Area and border management agreements. And then more human rights protections and international law, as already highlighted in several clauses above. Several submissions relate to stress the need for the bill and subsequent agreements to explicitly incorporate and prioritize constitutional and human rights law, refugee law, and principles of non-refoulement. And the concerns raised about the lack of explicit safeguards for individuals, especially vulnerable groups within the common control zones. Corruption and oversight. Again, several submissions highlighting the high risk and prevalence of corruption at border posts, especially concerned the bill lacks specific mechanisms to address or combat corruption, and that reference should be made to include specific reference to potentially drawing from mechanisms in the Refugees Act to establish an independent border oversight authority. That's from Tato Seleke, to ensure accountability. Again, to start to emphasizing the need for clarity of roles between the role players, BMA, SARS, SAPS, and SNDF, and that they are properly resourced to fulfill their mandates effectively under the one-stop border post model. They're also concerned about potential job losses for existing officials, despite the need for more staff. The vulnerable groups, asylum seekers, children, and stateless persons, several submissions emphasizing the need for specific provisions and sensitivity towards vulnerable groups, including proper identification, processing according to international standards, access to social workers, and protection against the refoulement or arbitrary detention. On the NEDLAC process that led to the draft bill, COSATU was deeply concerned that the Home Affairs did not table the bill to NEDLAC for engagement with social partners, such as organized business and labor, prior to the tabling at Parliament, despite a prior agreement and in violation of the NEDLAC Act. Infrastructure, technology, and funding. The submission points to the bill is silent on funding mechanisms for modernizing border post infrastructure and technology needed for the one-stop border post. And they recommend establishing a dedicated border infrastructure fund. Zak Desai recommends incorporating the use of advanced technology for real-time information sharing. In terms of the environmental and socio-economic impact, Tato Seleke recommends mandating an environmental impact assessment and stakeholder consultation for the one-stop border posts projects. And Zak Desai recommends the bill address the potential socio-economic impact on border communities, such as those who may be displaced and local employment or business opportunities. Voice for Human Rights raised significant concerns about holding facilities mentioned in the one-stop border post policy, which the bill enables, but though not in the bill itself. They warn against these becoming sites for prolonged, inhumane administrative detention like Ndela, and they argue against administrative detention and recommend that if facilities are used, they should be strictly for criminal detention, with human rights monitoring and clear definitions or administrative protocols. There's a recommendation that includes that there be provisions that include mandatory training programs for border officials, and that requirements for public awareness campaigns to educate citizens about the operational changes, and that there be monitoring and evaluation using metrics like processing time, trade volumes, and stakeholder satisfaction. So this doesn't really relate so much to the bill itself as perhaps to regulations or monitoring and evaluation. And then in conclusion, the five main issues raised are around human rights and non-refoulement, addressing corruption, legal clarity or where mandates overlap, and implementation and oversight, including funding and infrastructure, and procedural issues in terms of how the draft bill was established. Thank you, Chair. This is as concise as I can get the submissions. I hand it back to you. Thank you.
Thank you very much, Mr. Salmon. Members, these are the responses as per your decision to invite public comments or written submissions. Next week on Tuesday, we'll be conducting public or oral public hearings around this subject matter. Is there any other comment you want to raise? Because this is a process that of engagement with our stakeholders in our next committee meeting. And thereafter, we'll then deal with the deliberation of the committee. And I'm sure that we'll also request the department to also update us on the process that they undertake in relation to the P that they've briefed the committee earlier on around this border post, one-step border post initiative. Is there any other comment, members, around this process? Okay, I take it that is the brief, and we'll wait for the public oral submissions next week with our stakeholders. Is that my understanding, Mr. Matonzi?
Yes, Chair. So what we'll do next week, and then we'll put that matter of the immigration, because it was a legal service did brief the committee last week just to get those decisions made, and then from there we'll proceed with the public hearings. That's the Chairperson.
Okay, thanks very much. Honorable Ngobeni, I see your hand.
Thank you, Chair. Maybe just if Mr. Salmon, just a clarity-seeking question around the submission by Lawyers for Human Rights, if you can go there. I'm not understanding what it is speaking to when it speaks about criminal detention. Maybe just clarify, Mr. Salmon, because if people are here illegally, it's already what does it mean? I don't understand.
Salmon?
Thank you, Chair. Yes, there's a separation between administrative charges and criminal charges, and so immigration violations are seen as more of as administrative, not so much as criminal charges. So they're considered less serious than criminal charges, and it's a distinction in human rights law.
Okay, it's fine. Let's also deposit that question when they are going to appear before the committee in our next public hearing with the stakeholders. Noted. Thanks, members. So, Mr. Matos, next week we'll start with the matter that we've decided on, the immigration bill, but also the response from the Parliamentary Legal Services. We'll deal with that and we'll take a decision so that we allow them to proceed with the A list. And therefore, we then invite our stakeholders for oral submissions, which will also temper into our time. And I want to propose, members, that we consider to something that will deal with at MENCO. How many will be attending, Mr. Matonzi?
Chairperson, we receive about 8, and then I still have got 2 that are supposed to confirm this week. Yeah. So, and also to indicate, Chairperson, that the last time when we were at MENCO, you indicated that no, because of public hearing, also to cut costs for the stakeholders to come, because some of them they cannot pay for themselves, is that we should have a virtual meeting.
Yes, correct. Yeah, I think in a manner we dealt with the previous public oral submissions of immigration. We'll also consider, members, that we allow our stakeholders to utilize this platform to contribute, which is make it easier for other costs that could be incurred on their side. Can we step off this item? Okay. So next week, Mr. Matos, only 2 items in terms of the program that we may need to change.
Yes, Chair. It's only the immigration making that decision and then also the public hearings.
Okay. And then we'll end with the considering the minutes.
Yeah. If we still have got time to that.
Okay. I'll request that you also brief the committee next week on the preparations for the what you call the public hearings, briefly, what is expected, and also the matter of our study tour, briefly. We'll also commission a correspondence to the COC to, given the new setup in Parliament and more parties which have been not included and who are not forming part of this committee, including I've been informed by the leader of the I don't want to say smaller parties, but because that is the standard title that has been used previously by Honorable Van der Merwe when she was representing the smaller parties. I've been approached to that extent that the committee may need to consider to approach the COC to consider selecting those who are not forming part, because this is important subject of the e-voting, given that we'll be dealing with the the electoral reform panel report. And I'm sure that you're aware that the period of the report to submit has been extended by the minister, which I think we appreciate, for them to have enough time to conclude the report and then submit to Parliament. Will that be sufficient, Mr. Matonsi and members, if there's any other matter?
There's no other matter, Chair, from my side.
Okay, thanks, members. Just to remind that today we are presenting our report in relation to the threshold. And I can recall that our decision was to review the quantum, which we've carried in your report, and also to review the Party Political Funding Act. The quantum has been reviewed to 15 and 30 million, 280 million respectively, as a result of the conversation that we carried in the meeting. Thank you. Honorable Ngobeni, I see your hand.
Thanks, Chair. Sorry, just a matter of record for Mr. Matonsi. I will not be at the next meeting, but suffice it to say that if he can note the minutes of the 4th of February, just to have the record show my apology for that meeting, because it's not recorded in the minutes. Thanks.
Okay, thanks very much. Thanks very much, members. Thanks, Minister TM, DG, and the Parliamentary Legal Services, and all contributions that have been carried, and our decision for processing by the committee, and also the task that the department will come back to us to present on the follow-ups that we've been raising. And thanks very much. Our meeting stand adjourned.
Thank you, Chairperson.
Thank you very much,
Thank
Chair.
you, Chair.
Bye.
Thank you, Chair. Bye-bye.